are challenging the state's authority to create a post of supernumerary post. Now, the item number
The
2.
purpose to give sanction.
Don't add that. First of all, obviously it comes for what purpose you are creating. That is a deciding factor. In one word, they have the power. Are you not disputing? Don't have the power.
They have power.
Now, item number 2 is for the petitioner.
2, 3, 4, 5 in all the matters.
ছয়টাও কি supernumerary? Or you are also challenging? Yes, power of the state to create such post. Very well, 2 to 7. So let me take up one lead matter in this.
Item 5 in that.
Item 5.
But there we are for 391 candidates who would benefit from the creation of the supernumerary post because they were the victims.
How you have been added in this matter?
Lordship, we have filed our there are 2-3 such intervention applications which are pending before your Lordship. Lordship said Lordship will keep the intervention applications pending and asked us to file affidavits. We have filed affidavits as well, and Lordship said Lordship would hear us.
The basic thing would be, my lord wanted to get an affidavit from the state advocate general whether they would have the same point raised before the Supreme Court or not. According to us, the SLP arising out of the same matter is pending, which was preferred by the state. Since the court directed not an investigation to this matter also, therefore they went up to the Supreme Court, and the Supreme Court has stayed the part of investigation and direction upon the Education Secretary to appear in court. Therefore, this point, the learned Advocate General, the erstwhile Advocate General mentioned before saying that the Lordship cannot, or kindly do not take it up because same issue would be.
Because I actually wanted to have an undertaking from the state that this point will not be an issue or will not raise in the SLP incidentally even. That assurance no one can give. You cannot restrict the inquiry of the court.
No, on the contrary, what was also falling from the court on the last day is that if the candidates are allowed to join without prejudice.
That was not from the, that was a suggestion of advocate.
That's also a prayer, Lordship, which we are making, Lordship, suffering for several years.
And what fell from the court that if it is allowed, then it should be mentioned clearly on the appointment letters of each candidate that their appointments will be subject to the result of these.
What is the position of Supreme Court matter?
We do not know, because that is their procedure.
There are SLP by commission and SLP by the
state.
By the state. Against that investigation order.
Overnight, they went up to the Supreme Court to ensure that the Education Secretary doesn't have to face the court.
But those matters have nothing to do with.
We did. I don't see any harm in doing that.
Nothing harm.
My lord, only
I didn't say harm. I say it's politics.
That, my lord, subject to correction by my learned senior friend, my lord.
If the challenge goes, then only you will surface.
One actual clarification. No, first of all, this matter concerns a completely different.
Have I invited you? Or not yet? If the challenge is not sustained, then you will be surfacing. Wait for your turn. Let me hear the challenge. Let me decide whether it can at all be heard out or not. After considering the affidavit of the state.
Only one sentence that those matters are different. That's when my turn comes, Lordship will try and satisfy my. 391 চাইছি appointment. যাদের আমরা রেকমেন্ড করেছি আমরা অ্যাপয়েন্টমেন্টটা পেতাম।
That those who are expecting their appointment, if the supernumerary posts are created, they can they will be invited in the events the challenge is sustained.
We have filed our application is pending. Can see.
Now, in this matter, the state has used an affidavit in opposition. Right? Already affidavit in opposition is on record.
But there is a direction. There was no direction, in fact, but it was understood that we will come up with a supplementary affidavit.
Mr. Dotto, let you first understand what was the history behind it. As soon as the challenge was made, it is trouble to Supreme Court, whatever. Dr. Patro will be showing that that matter had no nexus with that. The query of the court was that when the matter is before Honorable Supreme Court regarding this particular type of post, can you assure that this issue, that power of the state to create such post, at least to accommodate this kind of candidates, there is no such power to the state. The state does not enjoy. This issue will not crop up in that writ petition. Learned Advocate General said that on instruction that assurance cannot be given. So in view of the matter, it was adjourned with the hope and trust that the time the matter will be disposed of by the Honorable Supreme Court, or you can get a clarification on the Honorable Supreme Court that this matter can be proceeded. High Court can proceed with the matter. At that stage, now your stand is that either allow us to give the appointment, even pending challenge that you will be mentioning in the appointment
Right.
letter regarding the abide by the result. And secondly, this will not be an issue before that matter. These are the two undertaking you
Right.
will be giving as today in this matter. Then I will proceed to hear out the matter.
Milord, to assist your Lordship, Milord, we have prepared a supplementary affidavit which is being affirmed. It can be filed in course within, say, next half an hour or so, where, Milord, we have categorically stated, number one, that the matter pending before the Supreme Court and this matter is different. Number two is the giving appointment from this wait list will in no way compromise the merits of the teachers. Number three is whoever will be appointed or whoever are in the wait list, Milord, they have all got marks above the cutoff marks. Number four, that the posts which have been created is only to ensure that those schools which does not have work education and physical education teachers, in those schools, Milord, they will be appointed. And number five, the most important is that it will be specifically provided in the appointment letters that the appointments are subject to result of whatever proceedings.
Now, already an affidavit in opposition,
Yes,
this was affirmed by Additional Secretary, Government of West Bengal Education Department, is there.
Yes.
Already an affidavit is there. And so the who is the 234 respondent number? 234?
maybe my client.
Commission. Have you got copy of those? 5 and 6. Who is 5 and 6?
Board and president.
So also the board.
Reply to much.
Sir, have you gone through those affidavits?
Those affidavits.
Hmm.
Mr.
The
Dotto.
affidavits have been filed with regard to item number 5.
And
So the
exactly,
lawyer of
I am
item
taking the item
yes,
number
yes,
5.
Yes, it has been.
Concentrate on item number 5.
এটা পুরনো অফিস 22
20 নভেম্বর 2022 না সে তো হতে পারে দিয়েছো
Sir, whatever what he is seeking now, it is the ground reality that some teacher, because recruitment process is now closed, there is no new recruitment. The schools are in need of teachers. I don't know work education or physical education, more in the basic subjects, the teachers are not available. However, this is not consideration if the state cannot create such post. You go through these affidavits, including the affidavit of this is likely to be filed today or whatever time you will be filing today. And you go through it so that you can address the court on your challenge. And this is the item number 5 will be taken up only and other matters will follow according to this. And whoever in item number 5, they can add their, after this decision, then the question of hearing the others. If I decide that no, this post cannot be created, then I will hear the parties on the point, if necessary at all. Now, how soon you can file this?
But I'll file it, but I'm told that within 5-10 minutes will come by
And if you want to use,
সোমবার তো হবে না সুপ্রিম কোর্ট
সোমবার করুন।
করে দাও না 12টায় করে দাও after the tea.
sir, tell me, you will not use any reply to these affidavits.
Well, it's purely question of law. I will argue not only question of law.
Very well.
in the factual background as not narrated in the petition and thereafter.
You go through it. Maybe you may feel necessary to use.
But before that, I think it's my duty to point out to your lordship. Kindly go through the order of the division bench.
Question, then where's the interim?
So there are applications filed by the School Service Commission before this court saying that these supernumerary posts are created to protect the illegal appointments.
My lord, I'm strongly object.
Wait, let him complete.
Now, that in those applications were filed and was sought to be withdrawn when I pointed out this to the Honorable Court that this is the game. Then the learned single judge refused to permit him to withdraw. They preferred appeal. Because the order of the appeal court is this. Well, I am told this is also part of the compilation given to your lordship. But
But bring it on record in the form of whatever it is. Compilation will not do. You bring it on record with this clear statement that this has happened and that has got a nexus in decision with the decision making process of this matter. What which portion you want to?
The appeal court will not permitted not our stand and said no, this application cannot be allowed to be withdrawn. These factors on court. From that, this SLP was preferred.
Are you suggesting therefore the till date that application is on record?
That's not my humble submission.
That point you are suggesting that application is still on record and they have not been allowed to withdraw it. And if they do not were allowed to withdraw, then whatever stand they have indicated in that application, that
stands.
remains.
That
That
stands.
remains. And any contrary, whatever comes from the affidavit of the state or the commission, you explain it if they want to.
They
take
can-
it.
I have been explaining every
Come with the-
occasion. No, let me submit one sentence. With the lead of my learned senior friends also and the learned advocate general, let me say one thing. We are in a court of law. When we make a submission in the court, the submission cannot be generalized. Two totally different set of supernumerary posts. My learned friend cannot say. my
No,
learned
Dr.
senior-
Dr. Patro, if the stand of the petitioner is that whatever stand you have disclosed to whom you wait, that actually has a bearing. You want to say no bearing with this. They will put it on record. You put it, you also on record in your way. After hearing you, I'm neither accepting his version nor I am accepting your version. I'm only asking them to put it on record. That particular affidavit,
That-
division bench judgment, all over. You have every right to show that supernumerary, whatever you have taken a stand
It's
over
not a
there.
question of right. My learned friend also, with due respect, should also be submitting correct facts before the court. Those supernumerary posts, the purpose for which they were created, the authority which wanted to create them, it was totally a
Very
different
well,
issue.
that is what
Nothing
in
to
your-
do with
in your-
this.
in your-
If there is
in your
room for any
affidavit,
confusion,
in your affidavit have you, Mr. Dr. Patra, in your affidavit you have disclosed so?
in my affidavit, in my
Show it,
submissions,
show it.
constantly,
2, 3, 4.
no, my affidavit, it was filed with regard to what direction was given.
No, in your affidavit, possibly you will be saying something. Show me from your affidavit.
If my learned friend says
Please
that
come.
this is the issue before Supreme Court, the same issue, then my learned friend will have to show it.
Yes, now show me from you that is a complete different set of.
No, I'm just checking because at what stage this affidavit was filed. This is a 2022 affidavit.
Yes, you filed it on 8.
Whether it was dealt with.
Because your stand is still clear that supernumerary reports where from it had traveled to Delhi, it is completely different supernumerary post. In your affidavit, you must have disclosed that. If you not, then you have liberty to file it.
Well, could I make a one-line submission?
Don't restrict in one line. Everyone is restricted to one line.
Milord, Mr. Bhattacharya's submission is that the supernumerary posts were created to regularize the illegal appointments. Let us,
That was your application of the.
yes, let us presume for argument's sake that this is correct. this is one set of grievance of Mr. Bhattacharya's client, my lord, which your lordship will finally adjudicate. Whether he is right or wrong, whether the state is right or wrong, your lordship is going to
I will
decide.
not go into that question. I'm only on question. Whether state can create such supernumerary post, then its ancillaries to whom to accommodate to whom.
Right, right.
If Dr. Patro is suggesting that supernumerary post, which was the subject matter of the Supreme Court matter, is completely different.
Yes, well, that is what, my lord, I'm trying to clarify. That's what I'm trying to clarify. Now, what is before the Supreme Court and what is Mr. Bhattacharya's submission are, my lord, what should I say, parallelly being considered in a separate set of facts. What is the separate set of facts? As Mr. Bhattacharya says, that why have the state created this supernumerary post? Whether state can create or not, that is a subject matter which your lordships will finally decide. Now, this has been created to accommodate the persons who have been illegally appointed. Or in other words, some people have already been appointed. Now, please put it in one compartment, which is the subject matter before the Supreme Court, and my lord may also trickle down before your lordship. Now, for which, my lord, we are today before your lordship is, my lord, on the question of, my lord, two subjects, people to be appointed from the wait list. Now, once I say that we are going to appoint from the wait list, it presupposes that these people have not been appointed or they are waiting in that queue.
That part goes.
Yes. Now, this part is what, my lord, we are seeking an interim order today that kindly allow these people to be appointed. So that, my lord, these schools which are not. Yes.
Teachers who are already on service.
Yes.
What is the necessity of creation of a post for?
Right.
Unless the persons, those who have lost their job at a situation
Right.
when some persons, the recommendation withdrawn somewhere around what the intervention of the court or the commission thought it expedient to withdraw the recommendations. This was to accommodate those job losers, not the persons who are already on this post. You cannot appoint a person twice. Therefore, now you are segregating.
Yes.
No, this was not our intention. That I understand. That this post is for the waitlisted candidate of work education and physical education. Now, at that point of time, one affidavit or application, is there some other supernumerary post for those candidates? Or this is the same supernumerary post you are talking about?
No, these are, my lord, different for these two category of my lord,
You have
teachers who
created
are
a-
in the wait.
Mr. Doctor, you have created a fixed number of supernumerary post, a fixed number of supernumerary post. This fixed number of supernumerary post, whether for what is the purpose? One, because of the one disclosure that to accommodate job losers or those who are in
Wait list.
waitlisting. If
Lord-
the court is found that you want to accommodate those job losers whose jobs are under scanner of the Supreme Court, High Court, this court will obviously not encourage, will not
Yes.
encourage.
Yes, my lord, I do appreciate, my lord. That is why, my lord, kindly have a look to, my lord, the order of the Honorable Supreme Court. I think the one which has been handed up to the court, my lord, this is dated 25th of November 2022.
Mm.
If Mr. Bhattacharya has have handed over, my lord, is it, my lord, 25th of November?
November.
Yes. Now, please take, my lord, the second paragraph. Dr. Singhvi, appearing on behalf of the petitioner, adverted to annexure P4 to the special leave petition, which is an application filed by the commission before the High Court in Can so-and-so in WP so-and-so. The paragraphs 5 to 8 of the applications are extracted below. Kindly skip over 5. Kindly take, my lord, quoted para 6 in the next page. It is thus submitted that if any other illegality concerning the appointment of Group D staff is identified, it is humbly proposed that apart from giving recommendations and appointment to the genuine candidates as observed by this court by its order of 21st September 2022, supernumerary posts be also created to accommodate those whose appointments are subsequently found to be invalid. Whatever it is.
No loss of job.
Yes. So therefore, my lord, two things.
Our intention was very clear.
Yes,
Intention was very clear
Yes.
that no loss of job.
yes. Now, my lord, whatever
If you
may
have
be,
already changed your intention, if you have already changed your intention, look here that we do not want to accommodate this, maybe whatever situation like. Now you want to use that supernumerary post to accommodate the waitlisted candidate.
No, not.
no, no. These are not those. That is what, my lord, we need to
These are
build.
completely different.
Completely different.
How many posts you have created?
এই যে notification টা,
Notification টা।
300 with petition at 300. This
My lord, please have a look to, my lord.
300.
Tell me now how many
And
posts?
1600 for physical education, work education.
Yes.
And the supernumerary post he's been referring to in the Supreme Court, what are the number?
My lord, the one, my lord, which I've read, my lord, please have a look at page 300. I think, my lord, this will get clarified.
Page 300.
No, my lord, that 19th May notification whereby the supernumerary
Yes.
posts were created.
ওটাই তো 300.
Yes. But this is, my lord, 19th of March, May 2022. Now, please take, my lord, the first recital, whether the proposal was sent to the state cabinet for creation of supernumerary posts of assistant teachers, including physical and work education teachers and non-teaching staff in the recognized aided sponsored schools as follows. A, creation and filling up of 5,261 supernumerary posts with the breakup as follows. 1,932 for 9-10, 247 for 11-12, 1102 is for Group C, 1980 for Group D. Now kindly take II. 1980 for Group D is before Supreme Court. Now please take II, 1,600 supernumerary posts of assistant teachers with breakup of 750 for work education.
You are on this.
Yes.
And
This is specific.
This is
So,
also not
so-
before this court.
yes,
D is for Supreme Court.
yes.
No, this is also not before Supreme Court. This
No, no,
entire issue
this is
is not.
Group D. What we mean is this.
This selection,
Therefore, my lord,
What
what?
restricted to 1600 only?
1600.
Please clarify in your affidavit.
Very good. Well, in that case, then in that case, where I need to, my lord, modify a bit with this.
Exactly. Clarify.
Yes.
Clarify it that this has got no nexus with the pending Supreme Court matter. Clarify.
No, that we have said, but this 1600.
Break up 1600. This one, the parts part the order of creation of supernumerary.
একটা
Because I am not getting it from the affidavit of the commission.
copy দে না এই অর্ক একটা copy দে
Dr. Patro,
my lord.
commission is supposed to clarify it in its affidavit because you are the recommending authority.
My lord. May I
And
just,
so also the board, the appointing
may I
authority.
just add, in addition,
Have you clarified it?
একটা দে না একটা copy দে
Have you noticed this situation?
Yes, on basis of this, we have said.
No, you have to clarify it.
physical.
The 1600 post. Yeah, whatever way you can, appointing authority, you must have some
May I-
knowledge about it.
may I just add a few words in addition to what Learned Advocate General has said? This is the notification. I am submitting that what is before Supreme Court, those supernumerary posts are not yet created. They are not part of this notification, not even the Group D. The Group D selection process, along with 9, 10, 11, 12, and Group C, there was an attempt on the part of the commission, not the state, to file petitions before the court, praying for leave to create supernumerary posts for those candidates who will be losing their employment. Totally different issue, totally different.
Explain
thing.
it in your affidavit.
Yes, we have already stated, we
Where
will
have you
further
stated
clarify
that?
in our next
Yes,
affidavit.
say that, just
And
tell me,
and-
show me
and
from
since
your
the
affidavit.
petitioners are submitting that everything.
So that I
which
can
is
invite
said-
the petitioner to combat it. Show it from your affidavit.
Just kindly see paragraph 7, page 6.
You are 4, 5, na? 2, 3, 4. No, you are
My lord, I am for responding
4.
2, 3, and 4.
which paragraph
Our
should I see?
affidavit dated 28th
Spec-
November. The issue we have started discussing from paragraph 6 onwards. But kindly see page 6, paragraph 7, the sub-paragraph at the bottom. with regard to the order dated 28/9/2022 referred to in the writ application, whereby it is mentioned that the CBI filed a report where there was certain manipulation of OMR sheets, I say that the said statements are connected with a totally different selection process. I am dealing with their statement in paragraph 5 of the writ application, governed by totally different rules, notifications, and not in connection.
Where from
with
you are reading? Paragraph 7
Paragraph 7, there is a subparagraph at the bottom.
with regard to the order.
Yes.
এখানে আরেকটা প্যারাগ্রাফ আমাদের অ্যাড করে দিতে হবে।
I say that the said statements are in connection with totally different selection processes governed by totally different rules, notifications, and not in connection with the instant selection
Make it,
process.
make it clear, a little bit clear. Now which way you are clarifying that this notification talks about creation of other 5261 of supernumerary post breakup has been given in 1600 is one of such breakup. And this 1600 is not the subject matter of any of the litigation before the Honorable Supreme Court. Clarify it by way an affidavit, not in this way, not this way. Make it very clear so that they can be asked to respond to it. Thereafter, I can take up.
I am actually the one who is responding. I am responding to their statement that everything is one big
No.
mixture.
They have taken, they have now they have used a supplementary affidavit, I suppose.
In the writ petition, they have confused everything.
No, in the supplementary affidavit, because of subsequent development of it, during the challenge it has happened. This disclosure of everything.
In response to that, I may submit that in a totally unconnected matter, they brought a CAN application from a different matter before a different honorable judge and showed it to
Of
the
course,
court
different honorable judge. Of course, that you need not point out.
and showed it to this court only to create the confusion. Only to create the confusion that was brought here.
That conclusion you have, that just now you want, if you want to clarify this situation, because already affidavit in opposition on your part is there. If you use a supplementary affidavit to that your opposition, so that I can understand your stand very properly. And Mr. Dotto, in your supplementary affidavit, clarify regarding concentrate on this 1600 post and to say that this has got no nexus with the Supreme Court matter. And accordingly, after giving, say, respond to it so that the your argument may be pinpointed to the challenge. So, you
But
just use it.
may I make this suggestion, Miller? But I'll serve a copy of my supplementary affidavit today itself to Mr. Bhattacharya.
With these changes, with
Yes,
these
yes.
changes.
It's already there. Maybe 1 or 2 lines I'll change. Let Mr. Bhattacharya's client Miller respond to it by Friday. Kindly keep it on Monday. I think Mr. Bhattacharya has got some difficulty on Monday. It can be on Tuesday also.
I want an affidavit from you also, with the same tune with the state, because you are the recommending authority.
I am only trying to distinguish.
No, you try it,
difference
try it,
between
try
what
it.
is
I
before this
understand.
court.
It is better if I come with
Yes.
affidavit. It will be better to understand for this court. So by Friday, you can do that.
Yes.
Hmm?
Yes.
By Friday, you can use a supplementary affidavit.
But may I make one submission, my lord? But kindly also consider, my lord, writ petition has been filed at the instance of the unsuccessful candidates who are not even called for personality test, my lord. They are aware, my lord, they were not even called for the personality test, my lord.
Then who are you?
My lord, we are the successful candidates, my lord.
Have I invited you now? The challenge is already there.
But we have taken out an application, my lord, which is pending, my lord.
I will post it in the month of April or May. Don't disturb me. Wait. What I told last occasion, you are only interested to get the job.
If I can get the copies of the affidavit from the commission.
Supply him a copy. Supply him a copy.
এবারেই তো ঘেরা হয়েছিল।
Supply him a copy.
And what about the other post?
Yes, Mr. Das. I asked Mr. Bhattacharya whether he can. Because state, that
কি post
state
বলছিলে
cannot.
তুমি?
What post has been created? Yes. Hey, এদিকে এসো. By Friday you were using
No, I am using by today.
the leave as prayed for is granted to the commission and the state to file a supplementary affidavit to their respective affidavit in opposition. Mr. Dotto, it will be a supplementary affidavit to the affidavit in opposition already on record. Because that supplementary affidavit in opposition was affirmed by the additional secretary to the government of West Bengal. This was affirmed on 28th November. Huh?
না ইন অ্যাডিশন টু ওটা করে দিচ্ছি চেঞ্জ যখন হচ্ছে ওইটুকু করে দেয় একটা লাইন বললে না না এই লোকটাকে ধরে রাখ এই
To affirm and affirm supplementary affidavit to their respective affidavit in opposition to the writ petition by Friday.
আমি করে দিচ্ছি কেন
Copy of those supplementary affidavit be circulated to the learned advocate for the appearing parties. I cannot record your service. Mr. Dotto, Mr. Shanal should get a copy.
হ্যাঁ সে দিয়ে দেবো
Tuesday, sir, Tuesday.
Will get filed by Friday afterward, even at least 3-4 days to file a reply.
Tell me.
They will file by
টুডে
My lord, kindly give us till Monday because we are not getting any working days if it is on Friday, by Friday. Let us do it by Monday.
Well, if they file by 19th, I shall get reply by 23rd, 24th, 26th.
26 instead of 28.
By 19th February. করে দিন ওটা ফ্রাইডের জায়গায় 19th February. The reply to the said supplementary affidavits be affirmed. Tell me the date within which time you can affirm your
If they file by
Monday.
Monday, I shall file by Friday, 23rd, 4 days only. 19th, 23rd, matter may be taken up on 28th. As per
created by
দেখো ডায়েরিটা দেখো
memo dated 19th May
28th by 23rd use your affidavit, affirm your affidavit by 23rd. Matter will listed on 28th. 10:30
Sure.
and not under supernumerary post.
ক্লার্কের রিপোর্টটা ডিপেন্ড করতে হয় না
It's only a request and nothing more, lordship.
Then this, I'm telling you, Mr. Challenge, if this expecting the aspirant candidates intervenes too much, I will release the part heard. Unless the challenge sustains or goes, then how can you?
We were making a different submission, lordship.
Divide submit, make
One request because Mr. Ghosh was here only on the next occasion. Kindly consider matters sympathetically once the Advocate General files the affidavit. That is all the joint submission we'd make. Nothing.
sympathetically. Pursue the Mr. Advocate General, the affidavit must be convincing affidavit.
Only that much, nothing.
But there are other issues also, Millard, because Millard, we are aspirant for the physical education. The petitioners have come
In
up for
physical
the
education, Advocate General is much more interested than you.
yes we need to be physically fit but what about the other posts
Other post, that you cannot create.
our
That you cannot create. That for this is a completely unconstitutional post you have created.
ইয়ে কোথায় গেল তার কত গেল কোথায় চলে গেছে ও সুপারিমারি কথাটা বলতে পারছি না
So
Sir,
get
final
the all affidavits and deal with in that way. Separately, please separately, because your replies are still wanting. Your replies are still wanting. No. Check up the record. Your replies are not there, I suppose. Check up the record. Unsuccessful? You are appearing for the one of the some of the applicants.
Yes.
Whatever results of this exercise. Huh? No, sir, one thing. So far, if the challenge is not sustained, challenge is not automatically your. So there is no. If I think that any law point I want to hear you separately, then I will invite you. Whether you sit here or whether you sit in the bar association. No, I'm trying hard because so long this was given the understanding that unless Supreme Court matter is over, this cannot be heard of.
Milord, that was a misleading statement made before your
Not
lordship.
misleading,
Because the issues were totally different, Milord.
that he is harping from the
That
right.
has to be clarified by this stage.
No, I've been trying from the first day, but unsuccessful.
Unsuccess.
Grateful lordship. Grateful lordship. In court.
Must bring your senior on that day.
My lord.
Please come on that day. You may not be required to on the point how your clients are suffering. On a point of law, creation of the post supernumerary post. What are the situations when such post can be created, and whether to whom you want to accommodate is a relevant issue in power of the in assessing the power of the court
No.
of the
যেটা এতক্ষণ হচ্ছিল সেটাই চলছে এখন। ওই অরুণাবতা
Only on the legal issue.
No, so long we are dealing with some illegal issues.
My lord, kindly will also permit us. We are led by Mr. Parthasarathi Sengupta. Lordship will permit Mr. Sengupta.
Oh, really, always pleasure to hear the big lawyers. Bring everyone.
But I have an indulgence to pray, Milord. But there are a few matters, Milord, fixed at 2 o'clock. Mr. Bhattacharya is there for the petitioners. But I was only praying, Milord, if your lordship may kindly accommodate today and keep it, Milord.
Mr. Dotto, there is some problem on 2 p.m. fixed matters. Please be present. It has taken a serious shape. Please come.
ঠিক আছে।
I will not take up the hearing, but I would like to apprise
Very
you so that you can take some steps.
Very good.
Send.
Very good.